Section 687.
Yes.
On this alternative set of appeals from the individual partners, the revenue have issued closure notice seeking to charge income tax on the vested awards. So the actual awards that were made by way of reallocation of special capital in the years in which those awards were made.
So that'll be an assessment in a different amount and in a different year.
Yes. Wait to see until the awards for each period are vested, and that was they will be charged. And as we saw yesterday, 687, Latoya provides that income tax is charged under this chapter on income from any source that is not charged to income tax under or as a result of any other provision of this Act or any other Act. And I agree with what my learned friend said yesterday, that this does not alter or expand the provisions. This was the Tax Law Rewrite Committee doing its job of modernising the section. And one of the main points of difference that arises from it is that it uses this concept of income. The old Schedule D Case 6 used the concept of profits and gains. And the courts had to then sort of interpolate as to what that meant. In using the single phrase income, concept of income, the section now sort of fuses much of the sort of case law on profits and gains and what that meant into one single concept of income. My learned friend took you to some cases like Kerrison, where there have been looking at Schedule D Case 6, breaking it down into its elements of annual profits and income and analogous to other income. Really, the concept now for the court to look at is look at 687, and the essential question is, have we got income from any source not otherwise charged to tax? It's been repeatedly said that the section is of wide import. It's the sweeping up provision, one can test that why we say that this concept of income doesn't expand, or income from any source doesn't expand what was said before in any material way by looking at Jones and Leeming, which was perhaps the source of the idea that one had to find income that was analogous with other income in the cases of Schedule D. And actually, I'll say that, read properly, the case law has always been that one's essentially concerned with the single question of is it income, although it may be helpful to test whether that income is, what they're really saying, is it income for income tax purposes. So Jones, I think, is in bundle 1 at tab 23. And it's the page of Viscount do you need in it, page 176 of the bundle. Where the origins of the Euston generous rule trace back to this concept of profits and gains. On the face of it, if one had a charging provision that charged profits and gains, that was sort of fairly limitless. But the courts had said, as Dunedin points out in the first paragraph break, the limitations of the words profits and gains were pointed out by Justice Blackburn in the Black case, when he said that profits and gains in case 6 must be profits and gains. A Euston generous with the profits and gains specified in the preceding 5 cases. And then came the memorable and off-quoted words of Norton and the London County Council case, where he begged to remind people that income tax is a tax on income. And the only question, therefore, here was there in any sense income? And interesting that Attorney General and Black case referred to there, my learned friend mentioned it yesterday. It was a case concerning coal dues that were payable if you deposited coal on Brighton Beach to some sort of local authority, and the reasoning of Justice Blackburn was that, well, coal dues are analogous to sort of harbour dues, and harbour dues are analogous to tolls, and tolls were charged to income tax under Schedule A. So the reference to the 5 cases in Schedule D is a little bit limiting. The true question is it the thing that you're looking at in the nature of income, and that is made so much more clearer now by Section 687.
Perhaps it's really just a quibble. It does seem to me logically there is a wider net cast by the reformulated provision, not least because it's not tied to other cases of Schedule D, as was. I mean, for example, an analogy with employment income would obviously work perfectly well for these purposes.
Yes, but that was in Schedule D.
But
Most employments were in Schedule D before. Some of it were moved to Schedule E. I think there was a distinction between employments in public offices and other employments. It certainly covered that.
Okay, anyway, but in any event, I don't think anything really turns on this.
No.
But if it did make the law clearer, so much for that.
Yeah, so we're all in agreement. But the critical question is it income? And in an approaching that case, we agree that if one's looking at the central case of what is income, then it's helpful to look at the past cases which have decided what is income, because there is a concept of analogy going on here. If you can say that your payment or your receipt is analogous to some form of taxable income, because it has the generics, the nature of income, then it falls within 687. But one's not sort of applying restrictive approach of looking at the characteristics of how coal dues are set up, or what sort of contracts are entered into. It's just is the nature of the payment of an income nature in accordance with the case law, and as good a case as any, and the one that the FTT took into account in reaching its decision, which provides a good thumbnail sketch of the basic distinction of what falls within the residual charge as income and what doesn't, is the case of Ryle and Hoare. It's a first instance decision, but it is repeatedly relied on in further cases as a sort of good thumbnail sketch, and it's a decision of Mr. Justice Rowlatt from 1923. And it was a case where 2 directors of a limited company had received commissions from the company in return for guaranteeing the company's overdraft. There was an initial commission for guaranteeing the loan for a year, and then a further commission for extending the loan. So Justice Rowlatt sets out the facts at page 160 of the bundle, tab 21. And so the directors were saying that, this was just an isolated example. It's not really income at all. And in his judgment, Mr. Justice Rowlatt gives a sort of a description of what falls in and what falls out of the concept of annual profits and gains, and we say this applies equally to the concept of income. And it says two emoluments may be excluded in case 6. This is the top of page 161. First, anything in the nature of a capital accretion is excluded as being outside the scope the meaning of these acts confirmed by the usage of a century. For this reason, a casual profit made on an isolated purchase and sale, unless merged with similar transactions in the carrying on of a trade or business, is not liable to tax. Profits or gains, in case 6, refers to the interest or fruit as opposed to the principal root of the tree. The second class of cases to be excluded consists of gifts and receipts, whether the emolument is from a gift into vivos or by will, from the finding of an article of value, or from winning a bet. All these cases will be ruled out because they're not profits and gains at all. Without giving an exhaustive definition, therefore, we may say that where an emolument accrues by virtue of service rendered, whether by way of action or permission, such emoluments are included in profits and gains. So this concept of things being outside the sweeping charge as being sort of capital accretions or one-off purchases and sale, where your profit has arisen from a capital transaction, is well embedded in the case law, and equally well embedded is the concept of if your income is being received for providing any form of service or doing anything, then it can't be sort of equated with a capital accretion. Or, so in the first-tier tribunal, what was being said that overall this was to be characterised as more of a voluntary payment, so it fell within the gift.
Why is a casual profit made on an isolated purchase and sale not a profit? I can see it's not annual, but why is it not a profit? Why can't I say I made a profit selling my house?
I think it probably is a profit, but not in the sense that it's being charged to income
So
tax.
when the judge says all these cases must be ruled out, he's not just dealing with a second class of case, is he? He's dealing with both classes, or is he just dealing with the second class of case?
It sounds like he's dealing with all this quite incomprehensive, but I think what he's saying is that profits and gains of that kind, an isolated, that falls into his sort of capital.
Well, then I can understand, but that doesn't. I wouldn't have thought. In ordinary English, doesn't stop it from being a profit.
No, I think that's true. I think that's true. Yes. I think as I think when he says first, anything in the nature of a capital accretion is excluded. For that reason, a casual profit.
Yes, I understand that.
A profit that arises just because you bought and sell an asset is a profit that arises on a capital transaction.
Well, unless it's an adventure on the nature of trade.
Exactly. He makes that point, and he makes that point.
A single transaction can give rise to taxable income if it's a
It's
trading
developed a
transaction.
little bit. But the borderline between gifts on the one hand and sort of capital asset disposals on the other hand, and other income, the only thing that he positively includes is any emolument by virtue of some service rendered, is a good sort of dividing line. And so the central question here is whether the receipt falls into the line of being some form of emolument for any sort of service rendered, or whether it's sort of capital or accretion, or is it like a gift? As I said, in the FTT, the individual appellant sought to persuade the FTT that it was in the nature, because it was discretionary, there was no sort of source, they didn't have any sort of right to it. What happened was that there was an award that was made in their favour, and that was, like I said, in the category of gift. And we say that the FTT was right in saying that that's not what the evidence showed. What the evidence showed was that this was an award that was made under a scheme that was intended to incentivise the individuals and to retain them. And as we've seen, in order to get this award, the individuals had to satisfy certain conditions. They wouldn't get the award unless they stayed working in the in the partnership, and they didn't resign, and they didn't commit any of the breaches. And if my learned friend is right, and says that they had to, there were these other forfeiture conditions which are unspecified, then they had to do all that as well. But in return, if they did provide all that to the partnership, then the partnership had agreed with them that they would receive a deferred share of the profits which they had previously earned. So the question is, what side of the line does that fall in? Does it more like of an income nature, or is it of a capital transaction? And we've seen that lots of the cases in dealing with D6, such as Brocklesby and Merricks and Manduka, all concern sort of one-off payments where typically alongside some other activity being carried on. And Brocklesby and Merricks was the architect who did very little for an additional piece of work. It fell out of his architect's practice. It wasn't charged under D1, but alongside that, somebody paid him an extra sum of money. That one-off payment was for some service, even very little. So it was chargeable to income tax under case D6. Manduka, the bonus case, where Mr. Manduka compromised the claim. He'd sued for his discretionary bonus. He got some money. It was outside the technical charging provisions because he wasn't receiving it by reason of employment, but it was a one-off sum that was related to his work, his services, and so he was taxed under D6. And the striking thing about this case compared with those cases is that these payments were a regular stream of payments coming from the partnership to the individuals, delivered year after year under an ongoing scheme whose very purpose was to deliver deferred awards to the partners as incentives to incentivize them to remain as partners. And if they did that, they got their profit share and they got an additional sum.
So you would say, looking at what Mr. Justice Rowlett says, that the initial, call it provisional award, was calculated by reference to services rendered, and further services had to be rendered in order for that award to become final.
Yes. Yeah. I mean, it's absolutely clear from the documentation, the scheme. That was what it was intended to do, and that's what it did do. So, you know, my learned friend says that well, first he says it's got to regard this as a capital transaction because the award was paid by way of a reallocation of special capital, and I think. When pressed, he said, well, actually, his argument didn't depend on that, because his argument would be the same even if it wasn't special capital, even if it was simply a money that special capital had and reallocated. But then he did keep coming back to saying, well, if it is capital, if one starts off with a capital payment, then you've got to find some other attribute before it can be taxed as income. So we said, well, if that were the case, there is a other attribute, because we have got clearly the attribute of the individuals needing to fulfil the forfeiture provisions before they got their additional award vested. But we say it's wrong to characterise the special capital as partnership capital at all, or as partnership property at all. It's not essential for our case for us to say that. We say, looking fairly at the limited partnership deed, it's quite like ordinary capital, unlike ordinary capital, and it is quite unlike what one would normally think of partnership assets. So if I could take you one more time to the limited partnership deed, clause 9.4. So that's supplementary bundle 1, tab 7. page 47. The features which we rely on saying, well, this is not partnership capital, are 9.4 A and subject to part. This is money that's held exclusively for the benefit of a single partner, and 9.4B, the partner who has special capital credited to his special account may, subject to any side agreement he's entered into, withdraw or part of such special capital. Now that's how special capital is treated, whereas ordinary capital cannot be withdrawn. The way that the partnership was funded in the ordinary sense was capital contributions, or 9.6 loan contributions could also be made to the partnership. Well, the clues that you get about partnership capital are in clause 14 on page 56. This is the limited liability of the partners. 14.1. The general partner links to the limited partners. They will not incur any liability for the debts and liabilities of the partnership in excess of their respective capital contributions under 9.1 and 9.2. So that's the ordinary capital. Special capital can't be used for that purpose. And 15.1 makes clear that the limited partners shall not be entitled, directly or indirectly, to withdraw or receive back any part of their capital contributions made pursuant to clause 9.1 and 2, but the new underlined lines make it clear that special capital can be reallocated and taken out, or taken out in theory before being reallocated. And then
the point about 14.1 is it makes it clear that special capital is not at risk in the business.
Yes. And clause 23.3 makes it clear it's not regarded as a partnership asset.
Sorry, did you say 21?
23, I think.
23.3, talking about on the dissolution of the partnership, where it says on dissolution of partnership assets shall be disposed of in such manner as the general partner determines. But then in the new underlined part below, any special capital credited to the special capital account shall belong to and be distributed to the relevant partner. So again, there's a distinction here between partnership assets disposed of by the general partner and special capital, which goes to the person with the special capital account. So those all make the point that this particular type of capital, labelled special capital, is not an ordinary capital in any sense, or a partnership asset. And so we would say that in the example that your lordship gave of mother and father, just putting the farm at the disposal of the partnership by some sort of license, that isn't a partnership asset in the same way. This isn't a partnership asset. And my learned friend took you to the passage on Lindley, so to suggest that, well, actually anything could be like, for example, your lordship gave would be a partnership property. but we say that that doesn't follow. Then if you have the supplemental bundle at tab 5, the chapter 18 of
Well, that's not what this is anyway, does it? I mean, he begins by drawing a distinction between between joint estates of the firm and separate estates of the partners.
yes,
In my lord's example, that the house is a separate estate of the
yes,
parents.
yeah, I agree with that. Also, Lord Lindley's definition is really used for a different purpose here. But well, Lord Lindley's definition starts by saying that the expressions partnership, property, etc., are used indiscriminately to denote everything to which the firm, or in other words, all the partners composing it, can be considered to be entitled as such. So, and then what it's saying is that, well, you have to qualify that in the case of so-called salaried partners or fixed shared partners. In that example, you'll have some partners that aren't entitled to property as such. But
We query whether they are in fact partners. They're certainly
not
held
off.
out to be partners, but whether they are
Exactly.
partners, if they're salaried, is not an easy question.
um,
But the rest of this chapter, which we haven't got, goes on to have a long discussion of what's separate property and what's
So we would say that special capital is the sort of thing that one comes across frequently in tax planning. It's a feature of something that's been given a name, special capital, to serve the purpose of the idea. But that's what it's doing. It's not capital in any sort of meaningful partnership law sense. We say it's not partnership capital at all, because if it were partnership capital, our argument would not alter. Our argument would say if it was some element of partnership capital, at the time it is converted into something which is ready to take out by the partnership, it's just money, the right to money, then it's income.
And ultimately, it's just a label for a certain category of money, which is used for the purposes laid down in the deeds. One can't help suspecting that it was called capital just to help try and give it a non-income flavour.
Yes. So,
Labels don't, anyway.
Deferred profit account wouldn't have quite done the trick. So we say it's properly regarded as something discrete from ordinary partnership capital, but in any event, at the time of vesting, what the individual gets is the right to take the money out or the investment out, but that is money or money's worth, which is certainly capable of being subject to an income tax charge. So then, although my learned friend accepted that his argument didn't turn on it, he did keep saying that, well, you need some special attribute if it is capital. So we say we don't need any special attribute because it's not capital. The only question is it income? Is the award that vests income in the hands of the individual partner in the year which it vests? And we say, well, yes, it is. It's just it's something of value, money or money's worth, which is vested in the individual because he's satisfied the forfeiture conditions. So then his fallback position, or maybe his main position, was that well, because the profits have been taxed in the hands of the partners under Section 850, then any further payment made to the individual partner can't be the subject of an income tax charge. That, there's no authority for that proposition, and we say it doesn't follow from anything, that you've just got to look at the payment or the receipt in question and ask, well, does that payment, does that receipt have the character of income? It's a separate payment. The partners have received their profits. If they enter into separate arrangements to make payments to reward or incentivize partners by making additional sums to them in addition to the profits that they're earning in that year, and they do that regularly as part of an incentive award scheme, it's difficult to think how more clearly that could be of an income nature. And the fact that the profits have borne tax in the past is irrelevant. Now, below, the appellants had tied the this concept that you can't have a further tax charge if the income comes from post-tax profits, because that would be double taxation. And that argument has been rejected below, and it wasn't really focused on by my learned friend. It was rightly rejected because it's not double taxation of the same income. If you arrange your affairs that Mr. A gets profits, and then Mr. A agrees out of his profits to pay something to Mr. B, and the quality of the payment to Mr. B is income, then it's an income payment.
And to take a simple example, if you're a trader and you invest part of your profits in buying an annuity, the income from that annuity is going to be taxable income in your hands, notwithstanding the fact you bought it with the fruits of your efforts.
My lord, yes. So and here it's if Mr. Platt had agreed to pay some of the some valuable group of traders extra amounts because he valued their service and he wanted to keep them working. He said, "Well, I'll pay you, £5 million a year to stay," and he did that for 3 years. What possible basis for saying that that's not taxable income in their hands? So we really said this isn't a borderline case at all on the issue whether it's capital or income, or whether it's chargeable to income. The tribunals below were right. My own friend criticised the FTT for not having asked itself the right question, but with respect, if you read the passage where the FTT deals with it, he essentially asks itself, well, is this receipt analogous to some other form of income? So he's doing a composite test, as he's entitled to do, in answering the question, was it income? Well, was it analogous to another sort of income? He said, yes, this is just like a bonus. And took into account the fact that that's how that was the origins of the scheme. It was brought in to replicate a deferred bonus scheme that Mr. Platt or someone had seen in a former life.
Is that a question of fact or of law? Or mixed?
Well, the question about whether something is
Income.
I think I agree with my sort of learned friend that it's usually a question of law, but there may be sort of, I mean, if he's applied the right.
Well, the reason I ask is that if Mr. Peacock is right to criticise the reasoning of the FTT, then it's open to us to decide whether it's income or not. If on the other hand it's a question of fact.
I think with all these, if the FTT has applied some wrong test, then the court will normally want to intervene in an issue like this. But
I may be out of date on this. My recollection is from many years ago that the question whether a receipt is capital or received on capital account or income account is very clearly now established to be a question of law. I mean, there was a lot of case law which pointed in different directions, but the House of Lords settled the point, and I think it was Beecham and Woolworth, particularly because they were overruling a court of appeal which had held it was all a matter for the, as it were, discretion. And then they said, no, it's not. It's a question of law. It's a hard-edged question of law, however hard it may be to discern the relevant criteria.
Yeah, I'm happy to accept that. But our point,
things may have moved on since then. But I mean, that's where I start from.
Yeah. Our point is that the criticism made of the FTT was he didn't ask itself whether it was income or not. And he said, well, he did ask himself whether it was income. He approached it by saying, is this some analogous to some other form of income? If so, it's income. And that's right.
But if it's a question of law, it doesn't matter.
No, it's true. Well, I mean,
he may have asked himself the right question and got the answer wrong, or he may have asked himself the wrong question but got the answer right.
Yeah.
It doesn't matter if it's a question of law, it's for us to
Yeah.
decide.
Yes, but I suppose it's a question of, it is a question of fact whether it's like a bonus or not.
Yeah.
And that was an important part of the reasoning. So,
All right, so
We
you
use
say
it-
you say it's
but-
income.
but
what,
the source.
what about any source? Yes.
Yeah, source. So the FTT held, and we say correctly, that there was a source, which was the exercise of the discretion by the company. On the FTT's reasoning on 50, the individuals didn't have any entitlement to the award until the discretion was exercised, and it was the exercise of the discretion which gave rise to an entitlement which the individuals previously did not have. And in my submission, that takes us squarely into Cunard and the reasoning of Lord Green, where he, in a very sort of similar sort of context, it was not Schedule D6 case, but it was still asking the same question. What was the source of the income in that case? And there you had a trust with a power to appoint monies out of capital to supplement a beneficiary's annual income, and the trustees exercised that discretion to award the capital to the beneficiaries to supplement their income. And Lord Green's analysis was that the exercise of the discretion gave rise to a new entitlement. They only had there were discretionary objects before, but on exercising the discretion they were entitled to, that was the fresh source. So that's Authorities Bundle 1 at tab 27. Page 255 final paragraph of 255. This McFeeters, so the beneficiary's title to the income, arose when the trustees exercised their discretion in her favour, not before. At that moment, a new source of income came into existence. So a title to the income arose on the exercise of the discretion. And there, as in here, there's no sort of dislocation, as my learned friend suggested, between the source and the income, because in Cunard's it was a discretion to apply capital, but the capital was being applied for an income purpose. It was being applied to top up the beneficiary's income for the year. That was clearly an income purpose. So that income purpose sort of characterised the payment as an income payment, and that payment had came from a source, namely the title of the income that was created by the exercise of the discretion. And so exactly the same way we would say here, the exercise by the company of its discretion to make final awards to the individuals gave the individuals a fresh entitlement to the awards. And that's the source, and then one characterises the payments by reference to the purpose of the award. What was it trying to do? And the award is characterised because the company was exercising its discretion to make these awards to the individuals under the scheme which the purpose of the awards was to incentivise them to stay with the partnership by continuing to work with the partnership. So that's the income purpose. So in short, we say that the decisions below were
Yeah.
right, the right decision, and if we're wrong on 850, then the individuals should be taxed on their awards as allocated. Unless I can assist you further, I'll hand over to Mr.
Yes.
Chacko.
Thank you, Mr. Baldry. Yes, Mr. Chacko.
I think you can.
Is the microphone clear enough?
Sorry?
Is the mic clearly not? Is the microphone clear?
Well, I'm not sure that's going to amplify your voice. I think that's just for those transcribers, isn't it?
Oh, is it? Oh, sorry. So I'm going to be addressing you on sale of occupational income.
Yes.
I was intending to take condition B first and then move on to the nature of a profession, if that's all right. So condition B is set out in section 777, which is in tab 12 of the first volume of authorities bundle.
Yeah. Yes.
So the question is, transactions are effected or arrangements are made to exploit the individual's earning capacity in occupation by putting another person in a position to enjoy all or part of the income or receipts derived from the individual's activities, or anything derived directly or indirectly from such income or receipts. And I think it's simplest if I start by explaining with an example how we say it applies here, and then explain why the various difficulties that Mr. Peacock has raised don't actually prevent this code applying. We are not trying to put a square peg in a round hole. I would say that these arrangements fit this code very neatly. So the easiest example, because we've been taken through it already, is to go back to some of the Florent Shermer documents. And so if you go to the first supplementary bundle at tab 25, so this is the email where he says how much he wants to go into the partner savings plan. And he says that he has a 4.2 million bonus and he wants to invest it in the partner savings plan. And as Mr. Baldry took you to earlier, he will have known what his bonus, which is to say his discretionary award was going to be that year, because this is the end of January, and so the calculations for the fund's profits will have happened by this point. And so there's his 4.2 million. And then if you go to tab 35, we see the provisional award letter for 3.1 million. And a few pages earlier, on page 248 in tab 31, there's a total list of awards. And as Mr. Baldry showed you, you can see his name is against this 3.094 million and against the 4.298 million, which was the bonus he'd asked to be put through the savings plan. So we say, you can look at the bonus that he would have been awarded as a profit share, and instead this gets allocated to the corporate member. At this stage, it looks like it's going to be Special Capital Limited. Eventually it turned out to be Avon, but it goes to the corporate member. So the question is, has the corporate member been put in a position to enjoy all or part of the income or receipts deriving from Mr. Shermatt's activities, or anything deriving from those income or receipts? And we say the answer is very clear. That award, which has now been allocated to the corporate member, represents income or receipts, which is itself wide language, that derive from Mr. Shermatt's activities. And in that sense, arrangements have been put in place that exploit Mr. Shermatt's earning capacity. And this, I say, is the reasoning adopted by the Upper Tribunal. If you go to the Upper Tribunal decision at paragraph 135, page 268 of the first one.
Yes.
And I say if you read 135, it's quite clear that that is the point that the Upper Tribunal is making there. You can trace through somebody's provisional total reward into the award that then goes to the corporate member.
Yes. In what sense was the corporate member entitled to, quote, enjoy, unquote, the
Well,
profit
we are
allocation?
proceeding on the basis that we've lost on 850.
Yeah. And
therefore its allocation has to be treated as its income. It's earning income, and so that I'd say I'll get on to whether this is income or receipts a bit later. But I'd say that all the reasons we've given all kinds of reasons as to why we say they don't enjoy what they're actually allocated to, and that's why we should run on 850. But assuming that you are not with us on that, then there has been an allocation to the corporate member instead of an allocation to the individuals.
Yeah.
And that is their money, and they do things with it. And Mr. Bobby explained why one of the things they do with it is pay out income, but failing that, they pay out capital, and that's where we get into here. So we don't think there is some kind of gap where where it is genuinely allocated to the corporate member, but you cannot describe them as enjoying it for the purposes of this code.
Yeah. And the assumption underlying this part of the appeal is that the payment out to the individual partner is capital.
Yes. Well, capital in these terms is simply defined as some other receipt which is not charged to income. So in those terms, it's necessarily capital because they are receiving something.
Yeah.
So we'd say that in that example, Mr. Shermatt had clearly given something up, and the corporate member has obtained something. So is what he has given up related to his earning capacity, and is what they obtain income or receipts derived from his activities? Those are the questions that the section poses. So first, his earning capacity. I would say if your income goes up because somebody else's income goes down, then your increased income is currently expense of their earnings, and it's fair to say that this has exploited their earning capacity. In a similar way to if an employer manages to pay below the market rate. In the first tier at 258, which is on page 141, Mr. Dodd's evidence was recorded, and it's that this is it's a people business, and it's one where people are very focused on their rewards.
Yeah.
And so it might be objected that he didn't have an entitlement to that bonus. It had been calculated, but it hadn't yet been awarded to him. But does that mean that he didn't have an earning capacity and didn't relate to his earning capacity? Because that isn't an established term elsewhere in the tax legislation. And I say it should be construed naturally, and it's what he might or could have earned, that because of his arrangement he does not earn. And we're assuming, because we've lost on 850, that he hasn't earned that money and somebody else, the corporate member, has earned it instead. Now, the fact that this is a partnership, I think this is one of the reasons basically why the tribunal and OD rejected condition. Does that raise a problem? Because you might say all the partners trade in business together, they have collective activity, the partnership earns the money. They don't individually have earning capacities that they can divert. They all earn the profits. And I said that's not the right approach, because the code is very widely drafted, and it's clearly supposed to deal with a wide range of business structures. So if a taxpayer became an employee and then the lion's share of what they might have earned themselves is earned by their employer, they may never have had a particular right to those earnings. I mean, going back to Black Nominees and Nickel, which is, while it was a Schedule D K6 case, is the kind of arrangement that this was targeted at. Judy Christie assigned her future income essentially to a company that would employ her before she had earned that future income. So she was expecting to earn hundreds of thousands of dollars in the next few years, but she had not in fact earned it. She hadn't signed those contracts. So at the point this money starts arising, she has never had a right to those contracts. They've always been rights in the hands of somebody else. That's not a problem. So, I say it doesn't, the fact that Mr. Shermatt did not have an automatic right to be paid that 4.2 million doesn't mean it doesn't relate to his earning capacity. Because I'd say that the earning capacity can include a chance of being awarded a larger share of the firm's profits. So, if you go back to Bucks and Bowers, which is an old partnership case, it's tab 32 of the authorities bundle, which should be, I think, in volume 2. My set's been divided up differently. Is it volume 1? Volume 1. And you go to page 355. If you look at between C and D on 355, Mr. Justice Penegrick describes a partner as earning his share of the profit. I feel that that's a perfectly natural way to describe what a partner obtains. Similarly, in this case, had you asked, for example, Mr. Dodd, what did you earn this year? He would plausibly have said what his share had been. He wouldn't say, well, actually, BlueCrest earned £200 million, and that's the only answer I can give to what I own this year because I'm a partner. We earn it all together. In ordinary language, a partner owns. You can say a partner owns their share. As I point out, that Bucks was dealing with a financial services firm. And then,
So you say a partner's share in the profits of a partnership is his earning capacity within that partnership.
well, his earning capacity includes his ability to have a share of that. And if his share goes down and somebody else benefits, then the person who's benefited that's come at the cost of his earnings, and they've exploited his earning capacity. He could have earned more and he earned less.
Maybe.
Well, I'd say in a case where it's directly one to the other, as in like here, where you've got a partner who says, I'm expecting to be awarded 4.2 million, but you will be awarded it instead. And further within this code, 784 and 785 assume you can talk about particular identifiable parts of a partnership's income.
784.
Yes, it's page 60 of the first of So these two sections deal, among other things, with assignments of partnership shares in return for capital. And that obviously would typically involve giving up future earnings. And if what you get is a fair price for your share of the business as a going concern, you're taken out of these provisions. But then 785 takes you back in if what you are doing in substance is forward selling your income. Because it applies where part of that valuation as going concern includes the prospective income or receipts derived directly from that individual's activities. And it's prospective, so it's implying that you will still be working for this business, despite having sold a share. And there you don't get relief unless you are being paid full consideration for your ongoing work. But the point that I take from this is that this code assumes that even in a partnership, you can talk about a particular individual's activities being the cause of part of the income or receipts, of there being income and receipts that derive from a particular individual's activities. So you don't just say, it's a partnership, so they all earn all of it, and they earn it together, and that's kind of the end. So I think it's fair to say that the partner whose share is going down, because some's gone into the PIP, is earning less, and so what comes to the corporate member is exploiting their earning capacity. And if you look at 780, which is on page 51, it says that account is to be taken of any method, however indirect, by which any property or right is transferred or transmitted, or the value of any property or right is enhanced or diminished. And the language here is extraordinarily wide. Mr. Shermart's profit share has gone down, and the corporate member's profit share has gone up, because that's how the PIP works. That's what it's supposed to do. And there's no realistic chance, for example, that Mr. Shermart's bonus was not going to be included in his profit share, but it wouldn't then go to the PIP. That's not the deal of these arrangements. So his part goes down, their part goes up, even if there isn't a contractual link between those. I'd say that's an indirect example of a right, because it's a right to share in the profits. We're assuming that we've lost on 850, so what the corporate member gets as a right to share in the profits has been transmitted, or its value has been enhanced. So does it matter that there isn't an explicit fixed right prior to allocation for Mr. Shermatt to get that 4.2 million? I mean, Mr. Peacock pointed in 3 to the statement at 3B2 that there's an assignment of rights in a partnership, and said, well, there has to be such an assignment of rights, so you're not caught if you're a partner. But subsection 3 is, it's headed up in particular. These are just examples. It's saying you need this formal structure or it just doesn't work. First, I'd say, in fact, Mr. Sharma probably did have enforceable rights. We cite Reinhardt and Ondra, and the passages in it are 410 to 412 and 447 to 8, that members of partnership, limited liability partnerships who have discretionary bonus entitlements can sue for what their bonus should reasonably have been. And in this case, of course, we're looking at a situation where he's already been told after his fund, after the performance fees have crystallised, what his bonus is going to be. So we'd have actually a very strong Reinhardt and Ondra claim, unless he sort of does something terrible in the meantime. But second, given that we've lost on 850 by this point, what has happened by the time of partnership allocation is that he doesn't have a right to share in the profits to the tune of that 4.2 million, which would have been the case if absent the PIP. And Avon does have a right to share in the profits to the tune of 4.2 million. So at least indirectly, I would say that rights have changed hands, been transmitted or enhanced. They have appeared in one place rather than appearing in another place as a result of the PIP arrangements. And I'd say it would fly in the face of this code to say that you can't take account of redirection of rights to income unless you have made some explicit assignment. That is not the way this code is drafted.
Does 780(1)(a) require the property or right to be transferred by the person with the earning capacity?
Well, given that it says to be taken of any method, however direct or indirect, I would say no.
So there is, in this case, a transfer from the partnership to the corporate member. There is a transfer of property. And,
Of a right, yes, I would say so.
all right. I think I'm not quite sure what the corporate member got, but whatever it was, they invested it in special capital. I'd rather assumed it was cash, but perhaps it isn't.
Well, I mean, in this sense that they have, given that the result that we're assuming has arrived on 850, they have a right to share in the profits.
Yeah.
But they also do obtain cash, and ultimately a large number of investments. So let's say there is rights and there is property. And the way the whole...
So the question then is whether that is a receipt which is derived from the individual's activity in the occupation.
Yes, and that's what I was about to move on to.
Yeah.
So is it fair to say that Avon's increased share represents income or receipts, even though in a sense, Avon, because it's a partner, already enjoys all the income and all the receipts of the whole partnership? And I'd say, well, yes, because income or receipts can mean a share of partnership income. Income or receipts is itself a wide term using different kind of concepts to show it's trying to cast its net quite widely. Bear in mind, it's also, they don't need to receive income or receipts. They can also receive anything derived from the income or receipts. And because the way that...
Where's the derived come in there? It's derived from the activities, isn't it?
If you go to 773B, sorry, 777 sub 3 sub B.
Oh, I see.
No, that's talking about something's derived from
from income which is derived from the
Yeah,
activities.
you
Oh,
still
I see,
need,
yeah.
Yes, you still need both,
you still need the income or receipts.
but it doesn't necessarily need to be the income or receipts that is the thing received by Avon. It could be they could receive something derived from it, but in this case, I say they do receive income or receipts. They receive because given the way that the partnership taxation code works, what a partner is taxed on, the amount of income they are treated as having is their partnership share, and so a partnership share is income. And so the question is that derived from the individual's activities? Rather than all the profits are derived from everybody's activities together. Well, if you go to the first tier's decision at 260,
Yes, we've looked at this.
yes. If you're talking about a discretionary trader, you know that their contribution to BlueCrest profits was carefully calculated, and the award in respect of that was then also calculated on a way that they would understand. And that's what they would expect in the market. It's clear from 258, which I took through earlier, that this is an area where they're very conscious of what the market rate for anybody's services would be, because people will move if they feel they're underpaid. And then for everybody else, systematic traders, administrative partners, the role of the remuneration committee is to decide what bonus reflects the contribution they have made to BlueCrest, because that's said in 263. And so I'd say that would apply, for example, to Mr. Dodd. His award is being calculated by reference to how much they're trying to find a proxy for what he's contributed to the business. And if you go to 348, which is page 182 of the bundle, of the first core bundle, he is doing very similar things to the email that I took you to with Mr. Shermat. Then he's been told how much is likely to be available to him, and he's saying how much of that he wants to be put into the PIP. 348.
Yes.
And for the third kind of trader, the systematic trader. So at tab 22 of the first supplemental bundle, you see this taking place for later. 22? I don't mean 22. Sorry, tab 3, page 22. First supplemental bundle. You see at the email at the bottom of this email to Leda Braga, she's being told what's available, which is the amount up to the discretionary 2008 profit allocation, and she's deciding how much of that will go into what was that stays still the savings plan.
Yeah.
So I'd say in all these cases, a serious attempt has been made to identify somebody's contribution to the BlueCrest business that year. A number has been put on that, which is their provisional reward, and that is what part of that then goes to the corporate member. So we'd say what the corporate member is getting which is a share of income, and so is income, does derive from their activities. This isn't a reward system as based as it were on fixed shares or capital ownership. It's based on an assessment of how much somebody's had to have activities that year have contributed to the partnership business. And I'd say that's very clear for the early years when there's a choice, but it's basically the same in the sort of mature version of the PIP when it's a simple 1/3, 2/3 division. You get that from on page 156. This is paragraph 301, box 5. And so it's point 3 in box 5, how they decide to split the total reward. Some of it goes to the individual, some goes to the corporate member.
Yeah.
So I'd say condition B is met in quite a straightforward way here. Because you can actually trace through an award that would otherwise have gone to an individual, goes instead to the corporate member, and it's directly at the expense of their potential earnings, and it's an award in respect of their activities in the business. And so I'd say all the conditions there are met. And the Upper Tribunal is right to find they were.
Mm-hmm.
Before I move on to profession, I just want to say something about 7, 7, 8 and 9 because the court had some questions about that, I think, yesterday. We have charged it under 778, which is where the capital amount does not consist of property which derives substantially the whole of its value from the individual activities or a right that does so. The question isn't does the capital amount derive from the activities, because it always will. That's what these provisions are doing. It's what's the capital sum you're getting being made up of. In this case, the capital sum you receive is made up of typically a series of investments in units in BlueCrest funds and so on, which mean it could also be cash. You could take it in cash, which means that when it's allocated to you, it has an immediate value. You know what that value is. And what 779 is dealing with is a situation Mr. Peacock mentioned yesterday in terms of how the schemes that were going on in the 60s that this was targeting. What you might do is sell your future earnings to a corporate in return for some form of loan stock or shares which would sort of fructify or become transferable as you did work. And in that sense, it wouldn't make very much sense that you probably receive all the shares on day one. This kind of is what's one of the features, though it's much more complicated in Black Norreys and Nickel. There was a loan that was gradually paid down as Miss Christie's employer would obtain fees for her work. So you could receive a capital sum where you just don't know what it is worth until you start carrying out the activities. But in this case, what you receive is a series of units in BlueCrest funds typically, or sometimes some other investment funds. So the question isn't whether the total value of the capital amount derives from your activities. In fact, you'd expect it to derive from your activities, at least in some way. It's whether what you're obtaining is property which is related to your activities. So if it's just shares you could buy on the open market, or cash, or fund units, you're in 778. If it's instruments that themselves will have a value that depends on your activities, then you're in 779, because it makes sense then to tax you when you turn it into cash.
Okay, so just to be clear, in the situation of your loan stock example, if it's paid down in accordance with future work and future receipts by
Well, if it means that you
then
could,
it would be within 779.
yes, it would be something where if you ask what is that worth today, and you would say, no, I don't really know what it's worth because I don't know what I'm earning until next year, then it's 779.
Okay. So 779 is really referring to the future activities.
Well, I think it is, because otherwise what you have in your hand in capital amount, the property or the right, wouldn't derive substantially its value from the activities of the individual.
Yes.
Though I don't understand that there's a, we have assessed under 778 and no appeal has been brought on the basis that we've assessed for the wrong year. I didn't understand that to be the challenge being made. I think Mr. Peacock was rather making a challenge that this just showed how awkward our attempt to apply these provisions was in this case. But I say it's not awkward. We say they received a bunch essentially of shares and units in funds, and those had an immediate value, and that's the value they should be taxed on.
It does lead, putting that interpretation on 779, effectively saying that what it's getting at is future activities.
Yes, I think it would be getting at future activities.
You'll then go back to 777 where you were, which also obviously refers to the individual's activities, but you're here effectively saying in relation to that aspect, look at the past activities.
Well, you're asking the question, you're looking at the capital amount, you're saying, well, what does it consist of? And it consists of properties. You're not actually talking about what the total value of it is. You're saying, well, what property does it consist of? And I think if you're talking about property, it derives substantially the whole of its value from the activities of an individual. That implies that that's property which will change its value in the period in which you hold it, depending on those activities.
Right. Yeah,
And
yes,
so it
I'm,
has to
I'm
be-
simply observing
Yeah.
that you are having to put a different focus on the concept of activities in 7773 and 779.
Well, I think that they are. I don't think they're necessarily particularly different sorts of activities, but I think that it follows from the idea that the property derives its value from activities, that you must be looking at activities that are carrying on. I mean, I suppose you could, I mean, it'd be unusual to have an instrument that simply derives its value from one person's activities in another circumstance. And it's also that condition B is talking about enjoying partly income or receipts derived from the individual activities, whereas 779 is about property deriving value from activities. So they are asking different questions.
Yes.
We're then going to move on to the occupation and profession test. So 774 states that reference to an occupation in relation to an individual, a reference to any activities of a kind undertaken in a professional vocation, regardless of whether the individual is carrying on a professional vocation on their own account or as an employer or office holder. So my understanding is that the appellant's real challenge is that what they were doing is properly described as trading, and therefore cannot be caught by these.
Yeah.
Now, the legislation doesn't mention trade. It doesn't have a let-out that says, if you are a trader, you are not within these provisions. And it doesn't have a caveat in 774 that says, not of a kind involved in trade. So the argument is that this is an implicit restriction, essentially because trades, professions and vocations are a set of clean categories that the three of them go together, and so if you mention two of them and not trade, you're implicitly excluding trade. And part of this seems to be an argument in the legislative context of 1969 tells you that they must have intended to exclude trading activities. And I'd say that apart from the fact that the core initial target was actors and musicians, essentially celebrities who could divert their income, the wording even then didn't contain an exclusion for traders. I mean, it may well have been thought that those who traded were not likely to exploit their earning capacity, but there isn't it's not one of the questions you're told to answer. You've never been told to ask, is this a trade, before you then ask whether it's a profession or of a kind carried out in a profession. I mean, it's clear from the old cases, mostly on excess profits duty, where there was an exclusion if you were carrying out professional activities. Like, was that many features of a business that are typically seen as trading features, such as buying and selling goods, make it very unlikely you'll be held to be a professional. And that was the argument that we had at first instance. We went through those cases, went through the way that these people made their money and what they did in the business. And the taxpayers lost. The tribunals held that it was right to describe these people as carrying out activities of a kind undertaken in a profession. But the fact that that is absolutely part of the historic approach to whether somebody's a professional or not is not the same thing as saying that there is an overriding exclusion that if you should describe these people as involved in trade, they're not in this code.
But if in 1969 Parliament had actually wanted to include trades, which after all were taxed under a different case of Schedule D from professions and vocations, it's very hard to believe it wouldn't have said so, isn't it?
Well, if they said so, then the regime would be wider. But the question is it a separate test? Because if it's not a separate test, then if you can fairly describe these people's profession as in of a kind of older profession, which is what the first tier has done.
See the attractions of that approach if one's approaching it completely cold, just looking at the present language. And maybe you'll say that we shouldn't go
Well, I actually
beyond
think that is what you should do, because it's not, post the tax law rewrite, I'd say it's very questionable to introduce a specific restriction on this code, which is not in the text, and in fact wasn't in the original text either, it's never been in the text, just because of the historical background to when this code was first introduced. So that's a very strange way to construe the legislation. So I'd say you can't assume from the background that there was a prior question you had to answer, are these people involved in trade? The question asked is, are these activities of a kind carried out in a professional vocation? So does that phrase alone implicitly exclude activities that could be described as trading? And I'd say if you look at the old cases about profession and about vocation, it's simply not as clear as that. The phrase trade, professional, vocation is a common phrase. It's not universal, but in these old cases. So if you look at Partridge and Maladine, which is tab 16, the oldest case I think we have, on this black is even older. Which is on vocation. If you go to page 78, the division is slightly different. So you see professions, employments, and vocations. That's at the bottom of 78. And again in Graham and Green, I mean, the point I'm making of this is that when we go through these cases, they're not actually setting out some very, as if there are a series of completely clear categories that you can always say. The scope of trade is clearly different to the scope of profession, but it's not a neat distinction.
They are, is this right? They are mutually exclusive, at least on the authorities. And although you might think a trade and the profession could often overlap, for tax purposes, that's not correct.
I would say that very similar activities could be described as a trade and could be described as a profession. You get those from these authorities. In fact, Carr, which I'll take you on, it actually describes that says that there are trades or businesses which we at a later stage when we call people may start to call professions. The judges are not actually saying this in such a fixed way. I think it is. I mean, Mr. Peacock used Maxey as authority for this. I don't think Maxey actually says that it's impossible to, that there's no overlap. It just sort of says that these are differing concepts, and I'll take you to that.
Sorry, but under the post-tax law rewrite code, there are still separate charging provisions, aren't there?
Yes, and I think you would have to say
Someone has to decide.
you do have to decide which one you are in, but when the question is, are these activities of a kind undertaken in a profession, and predominantly activities of the individual whose earnings are being diverted, not necessarily the body that carries on activities in the real world. I would say that it's quite possible that you could be carrying out activities of a kind that are found in professional vocation, even if the public-facing business is better described as trading. I mean,
so if BlueCrest had an in-house lawyer,
yeah,
there to advise on regulatory affairs or whatever, you would say that whatever the circumstance of BlueCrest itself, that person was doing something which is an activity of a kind, i.e. providing legal advice, which you find in the profession.
Yes, I think we would. No, we would say that. We'd say you're looking at the activities of the individual and how you would, and this question of a kind of the kind of activities you find in professional vocation.
Right. Now, where does the FTT make findings on what these people actually do?
Essentially from paragraphs 341 to 400 is a long section where they go through a series of sample partners and talk about what they do, what they spend their time doing. And it's against the background of that long set of findings that the rather carefully expressed decision at 451 to 455 has to be read. I mean, these were witnesses selected to represent a variety of activities that were involved in BlueCrest business that partners done.
Yeah.
So would it be fair to say your key point here is it's wrong in principle for the court to try and undertake a sort of archaeological expedition back to 1969 to see whether at that date legislation was not intended to apply to traders as opposed to people carrying on professions or vocations? We should take the legislation as it is under the tax law rewrite principles, and it then becomes a simple question of fact as to whether, in accordance with everyday perceptions, which may well change as time goes on, the activities in question can reasonably be described as amounting to a profession.
Yes, though I'd add that there are two ways that this restriction that the taxpayer seeks might arise. One is to say it's impliedly there in the legislation, and I'd say it's not there in legislation. And you not only should you go back to 1969, it wasn't there in 1969. You have to go back to 1969 and then look at the wider context, and that is a very awkward way to approach the tax law rewrite. Or is to say it's there in the meaning of the word profession, and is there in the old case on profession. They're all basically saying not trade. And I was going to take you, they're quite short cases, but through some of them, so that's not, there's nothing like as neat as that, the explanations given when they find or don't find that somebody is involved in the profession. I think my learned friend described it as these are cases like whether or not it's a trade or profession. That's not the question they're asking. They're asking, is it a profession? It's the overlay that this is some kind of dichotomy they always have to put it in is one that is not one you find in default cases. They do treat it as a strong indicator against being a profession that you're involved in the buying and selling of commodities or something like that. But they don't talk about this as if they are forced to ask the question, are you a trader, in order to answer the question, are you a professional? And so I don't think this restriction is there in the authorities either. Many people who would absolutely accept that the code would cover more things, it also said, of a kind involved in trade. There are certainly activities that a different first tier might almost certainly say were not professional. They would definitely say were trade out. But that's not the same thing as there being a separate question the first tier failed to answer, which is, are these people traders? They've got one question, which is, are these activities of a kind carried out in a professional vocation? So starting with Barker, which is the stockbroker, which is at tab, first bundle of authorities, tab 17.
Tab
17, first bundle.
17.
Yeah. I might take you to page 86.
Yeah, this is the stockbroker case.
Yeah. So at 86, if I could ask you to read the passage beginning, all professions are businesses, but not all, but all businesses are not professions, which is halfway down that main paragraph, just the end of that. The first line on the next page.
Now, this is an excess profits
Yes.
tax case. And we start off in section 39 with all trades and businesses. Then we've got the exception for husbandry, offices, employments, and any profession. The profession the reference to profession is itself qualified by reference to personal qualifications of the person who's carrying it on. And then there's a right back in, including the business of any person taking commissions in respect of transactions. So it's quite a complex definition.
It is, and so it's one of the reasons I said this is not the foundation for saying that either that anybody involved in making money out of commodity trading cannot be a professional, or that they are necessarily traders. I say that this is, if you read that page and the following page, it is a decision kind of in the instant case about whether these people are professionals. And one point in that is that while their fee income was held to be, they did have fee income, one of the pointers away from being a profession is that that fee income was held to be ancillary and attracted by their general business stockbroker. Whereas in many ways we say that one of the key indicators of being a professional as opposed to trading behaviour is that you make your money by providing services to clients in return for fees.
Well, this was an attempt to try and divide up the receipts, wasn't it?
Yes, and that was how you can't divide them.
Because one of the oddities is that what Mr. Justice Rowlatt said on page 229 of the report, page 87 of the bundle, is the stockbroker is remunerated by a commission which he receives from his principal. So even if it had been a profession, it would still have been included in the excess profits duty because it included business of person taking commissions.
Yes, they needed to have divided the fee, the advisory business for fees.
Yes, they were trying to.
Off
they were trying to
and say that was
carve it
both
up.
a profession and separate from the stockbroking business
Yeah.
in order to win.
So when Mr. Justice Rowlatt poses himself the question, is it a profession within the meaning of the section? Is he really asking the general question, is it a profession, having regard to the fact that his reason seems to be that stockbrokers are remunerated by commission? Because if they're remunerated by commission, it wouldn't matter whether they were or weren't professionals, as far as I understand the section.
I think he probably is saying, when he says within the meaning of the section, well, the fact that he's applying the Stratton quote in Burt's not in here, because it's quite a brief case. I think Burt talks about the sale of goods in the market rather than commodities, suggests that he's not just taking the point of commission.
Right. Yes, all right.
Yeah, and he finds that the advice given in connection with business doctor is not the exercise of profession. That's the end of that page. Because he's talking about the advice as exercise of commercial knowledge.
Yeah.
So I think he is making more, he's not simply saying it's because of commissions. But what I am saying is that he isn't laying down, these are all sort of pointers to working out whether or not he would describe somebody as a profession. He's not, there isn't a rule being laid down here that becomes clearer from the Court of Appeal cases. The Max C is the next one in the bundle. That's been decided a few days before Barker. I mean, there's the passage at the top of 99 where they talk about trades, professions, employments, or vocations. And there's, at that stage, he's taking the view, I think, that professions, employments, and vocation are distinct from trades, though in all the vocation cases, they seem to use trade and vocation almost synonymously. But then there's the lined passage as to what a profession is. This is a case of whether or not a proprietor and editor of a newspaper would be a counter profession.
And he does draw a distinction between profession on the one hand and an occupation is the sale or arrangements and production of sale of commodities.
Yes, and he says, but the line of demarcation will vary from time to time. And there's certainly extremes. I mean, even today, you would not say that somebody selling fruit will carry on a profession. You might, however, well say that there are financial professionals who are recognised as such in a way they might not have been 100 years ago. And that the fact that on some level you are involved with buying and selling investments does not definitively say that you're not a professional. I mean, even in the earlier cases, I think we get that from I think it's Curry. There's the example given.
Both sides in this appeal seem to me, and correct me if this is wrong, to be approaching this question on rather a blanket basis. It's either all the partners or none of them. Now, one can conceive that a case could have been made to say that whatever the position about those who are actually buying and selling the investments, the people who do the computer coding or design the algorithms are doing something which is professional in the sense that Lord Justice Scrutton is using, because that is the application of intellectual skill to design a computer program. But we are being presented with a rather all or nothing case, aren't we?
Because of the findings that were made, I think it would have been possible at least.
Well, that's why I asked you what the findings were, and there's a lot of recitation of evidence, but I mean, I suppose you say the FTT just accepted all that evidence.
I think we're assuming that where they recite if they recite a witness's evidence and do not say they disbelieve it, that those are their findings.
Because some of these people are doing different things, aren't they?
Yes, and they could have found that some of them were involved in profession and some of them were not, but that's not what they found. And there is no understanding, I think, a perverse stance being taken. If you go to 454,
Two.
454 in the FTP, which is page 219.
Yes, indeed, but that's a conclusion without a lot of reasoning.
There's a line towards the end of Carr. Carr is the one about the case about an optician. This is the Clapham Omnibus example. If you go 199 on to Carr is the one I was thinking of where he points where Duparc, this is on page 199, points out that he says everyone would agree that when you find a business, however extensive and distinguished, it consists merely of selling property. That's not a profession. Then points out that, of course, many professions...
What are you looking at, Mr. Chacko?
And that page 199 of Carr, which is tab 25.
Which you were 199 of the FTT.
Sorry.
Right. Tab 29, yeah.
25.
25. Yes.
And what I'd like to take you to is page 199. It's a judgment of Duparc.
Yes, indeed. He says it's a question for the man on the Clapham Omnibus.
But just before that, there's a passage where he points out that you may, in fact, be making money by selling things, but you would still be a professional, for example, a sculptor.
Yeah.
And then over the page, there is comments about how the meaning of profession changes. The profession of a chartered accountant has grown up in comparatively recent times, and other trades or vocations, I care not what word you use for them, may in future years acquire the status of professions. So one thing I take from that is that he is not seeing there is some absolutely neat distinction between describing something as a trade, describing it as a profession. And in all three of the similar cases, because taking this case, OD and HFX, the tribunals have found sort of those who manage hedge funds to be professionals. And I say that is the normal use of language now. We talk about financial professionals. And yes, we'd say that's extremely clear for the people who design complicated computer programs. But we would also say that for the higher end of bankers and fund managers. So when Judge Brooks says in 454 that these are not refers to the occupation requiring a purely intellectual skill or special skill or ability derived from experience, in the context of the evidence he's recited about the kind of scale and complexity of sort of what is one of the largest sort of fund management outfits in the world, he is saying the ordinary man nowadays would talk about these people as professionals. And I think you would say that the people who work managing funds in this way, even though what they are managing involves the sale of commodities, in modern language we would talk about them as professionals, and that's what's found. It's certainly been possible for them to have said we don't think the fund managers are, but we do think the systematic traders are, but that's not what they found. There isn't an Edwards and Bairstow challenge, and there isn't a challenge on lack of explanation. What there is a challenge on the idea that there is some overriding test of being, where you first have to say, are you a trader? And that test doesn't appear in the legislation, doesn't appear in the case law. It's true that a lot of the indications of things that you might call trades you would therefore not call professions, but in this case, the first-tier fund, they were of a kind carried out in a profession. Curry was the case, which I haven't taken, it was in the middle, I didn't take you to, where they decided that being a tax advisor wasn't a profession. But I think we would now tend to say it was. But going back to the statutory question, the question is, any activities of a kind undertaken in a professional vocation? And that is itself a composite phrase. These are all wide words. Occupation is a wide word. And so it's wrong. It's wrong to say that just because the partnership is best described as trading, these people's activities cannot be of a kind carried out in a profession or occupation. One of the ways it was put yesterday, I think at page 106, Mr. Peacock, this is page 105 yesterday, he said the Commissioner's case is that these individuals are carrying on a trade. They're taxable as traders, but because what you do looks a bit like what professionals do, we charge you on tax on the capital sums you receive. And that's actually pretty close to what the statutory question is. Are these activities of a kind found in a profession? You're not actually asking, is this a professional partnership? You're not asking, is it best described that fill its tax returns in on the basis that it's trading? You're asking what kind of activities do the individuals undertake? And now, is this too vague? And so it's not too vague, because this is targeted. This code is targeting any activity that depends highly on your personal characteristics and skill. Where it's plausible, you might sort of forward sell your earning capacity in return for capital. If you personally have an earning capacity that you can realistically divert, then it makes sense for you to be within this. And there is a tax avoidance overlay to it. And most people who would talk of as involved in trade probably can't do that. But fund managers of this kind absolutely can do that. They have very high earning capacity, and they can structure how they receive that. So if there isn't such a clear restriction, then you just have the finding of the first tier, which is that this is of a kind within a profession. And the appeal fails on this point, because these aren't defined words. The gist of taking the cases are ordinary English words that develop with time and should be applied at the moment. And none of these cases have set out an actual definition of profession. If there's no definition, then you're back in the Brutus and Cousins territory. It's ordinary English word. Has it been used in a perverse way? It's not perverse to talk about financial professionals in the modern day. And therefore, it's a reasonable decision. A final point on vocation. It's been said that vocation wasn't raised below. In fact, it was raised in the alternative at every stage. It's irrelevant, I would say, however, because if there is a test, as my learned friend says, that you first have to find these people are not involved in trade, then the first tier clearly didn't apply that test. If there isn't a test, then the first tier found that these people were involved in activities of a kind undertaking their profession, and that's sort of end of story. It doesn't really matter whether or not that could be described as carrying out a vocation.
But to go back to your example, you wouldn't normally talk about somebody with a vocation as a greengrocer, would you? Say he was carrying on a trade.
No. I think from Graham and Green, there's the impression that pretty much any organised way of making money would be a vocation. And these are definitely an organised way of making money. But if my learned friend can't persuade you that there is this overriding test that first they had to decide whether or not people were involved in a trade, then there's no Edwards and Bairstow challenge, so there's no reason to ask whether they're involved in a vocation. Yeah. And yes, similarly, if there was such an overriding test, then the first tier didn't apply it. I think those are my submissions on.
Right, well, thank you very much. Yeah, we're slightly ahead of schedule, Mr. Peacock.
We are. What I propose to do next, whether it's this afternoon or tomorrow morning, is to address you on the PIP Appeals, Ramsey, and then come back and give you my reply, which I anticipate will be short on both miscellaneous income and sales of occupation income.
Right.
We are ahead of the timetable. I'm content to start now. I'm equally content to come back at 10:30 in the morning.
Well, we might as well make a start.
Well, I propose to address you in relation to PIP Appeals under 6 headings. First, introduction and the starting point. Secondly, the relevant principles. Third, the application here of those principles and the first tier's decision. Fourth, the Upper Tribunal's decision. Fifth, what's wrong with the revenue's case. And then sixth, what would you do if you were to allow the Commissioner's PIP appeal, the consequentials?
Yeah.
So under that first heading, you've seen the relevant legislation. I don't need to go back through that. You understand now, as you almost certainly did before, how partnerships are taxed. Starting point is by Lord in Vanes. No difficulty about that. So the relevant question here, looking at the relevant statutory phrase of a profit-sharing arrangement, defined in terms of rights, here assuming that the rewritten legislation has the same effect as Section 114 of the 1988 Act, which is common ground between the parties. The question is one of rights. The starting point for that inquiry must be the partnership deed. The relevant partnerships here, as Your Lordship lady knows, whether it's the LP or the LLP, had both individual and corporate partners. They were treated by the revenue as carrying on a trade for tax purposes. That's one of the agreed facts. They were taxed on the profits of that trade, each of them by reference to their share of those profits, computed in the way mandated by the legislation. Those shares were fixed by the partnership deeds so that there was, in law, an allocation of profit to the relevant partner, whether individual or corporate. The
When
individual
you say they were fixed by the partnership deed,
provided for.
there was a, yes, the general partner exercised,
It was a waterfall, including a general partner's discretion.
yes.
So my lawyer's right, provided is a better term. The individuals were then liable to income tax on the share allocated to them. Corporate members liable to corporation tax on the share allocated to it. Pausing there to reiterate, partnership profits are taxed by reference to entitlement, not receipt. Where partnership profits of, say, 100 were allocated to the corporate partner, let's assume SCL, it had a corporation tax liability on that 100 of 28, and it was put in a position to contribute 72 to the partnership of special capital. Figures were different for Avon for reasons that we don't know, but it had the ability in its eyes to bear a liability ostensibly of 28, but to make a contribution to the partnership of 85. Those contributions of 72 and 85 to the partnerships by way of contributions of special capital have no bearing on the question of the share of partnership profits to which the partners were entitled. In the same point, another way, notwithstanding the subsequent contributions made by SCL at Avon, they each had rights to a share, by example, of 100. Looking at the partnership deeds, those individual partners had no right to that 100 that was allocated to the corporate partners. That 100 was not a share of the trading profit of the partnerships to which the individuals had rights. Now, if it is the case that there was an expectation, so if, let me assume for a moment, if there was an expectation on the part of an individual, they would come to enjoy the fruits of a contribution made by way of special capital, that does not amount to a right to a share of the profits of the trade carried on by the partnership. And the best proof of that is the fact that not all of the sums allocated to the corporate partner, the 100s, was in fact received, whether as 72 or 85, by the individual partners. 16% was not received and was retained by SCL or Avon as appropriate. And the commissioners, in effect, have no answer to that point in seeking to charge the partners, the individual partners, to tax on the sum of 100 allocated to the corporate member, where they had no right to that amount, and they did not, in fact, in some cases, receive that amount. All of this is absent some Ramsey argument, but the starting point for this court must be, at my submission, that the individuals had no right to the sums that were allocated by way of profit to the corporate members. The question then is there something in the principles that have developed in the courts since Ramsey that makes a difference here to that?
Can we just go back a step? The individual partners had no right to anything under the partnership deed in the absence of an exercise of the general partner's power of allocation.
Yes.
And don't think there's anything in the partnership deed to say that an allocation has to be unconditional.
No?
So it would be open to the general partner to say, I allocate you X, conditional on your staying with the partnership for 3 years. Now, would that not be a right, maybe a conditional right, but a right?
That would be a contingent right. But the legislation here uses right in the sense of a right to a sum on which you are to be taxable as a partnership profit. Your Lordship's example is not our fact pattern, but even if it were, I would say it is not a right to an amount that the individual should pay tax on day one at the point of
Well,
contingent
I
allocation.
can see that one might say that a conditional right is a right, but not a
It's not the
right, not a right for tax purposes until the condition is
not
satisfied.
the right sort of right
Yeah,
until the condition is satisfied.
yeah, I can see that. But
So that would be my answer to that variant.
but I balk slightly at the idea that a right must mean an immediate right. And it may, it's simply as a matter of the interpretation of the statute.
Perhaps put this statute aside. Let's imagine there's some other statutory context in which the word right is used. I quite accept that a court might conclude, because of the statutory context, that a right might include a contingent right. So I can't rule that out as a matter of logic. But here, the purpose of this provision is to take the profits computed in the partnership and then determine who shall pay tax on these profits of this year from this activity by reference to the rights of the individuals. And if you only have a contingent right, my Lordship's example, that is not the right sort of right as would engage these statutory provisions.
Suppose you had a right which was not contingent, or was contingent in the sense of being defeasible. So you get the money in principle up front, but perhaps subject to forfeiting it if you're not still in service 3 years later, and perhaps an arrangement to put it in an escrow account in the meantime, something of that description. I mean, could you then get a situation where you had to possibly do some kind of valuation or discount exercise or something like that to actually work out the amount subject to tax? But nevertheless, you would, it would all be as a result of an allocation which conferred rights which are not necessarily of the pure immediate type you're contemplating.
That sort of exercise would have to be done, my Lord, because income tax is an annual tax.
Yes.
It's a charge to tax in each year for each relevant period by reference to the profits of each period.
But in the right context, one is used to doing apportionment exercises, and matters of that kind.
It's not, but with respect, it's not just a matter of apportionment. It would have to be some kind of valuation in order to bring the notional value of a defeasible right into year one.
Yes.
But is that right? Because isn't the point that the partnership makes a profit of 100, and isn't the purpose of the rule to divide up that 100 and it should total to 100?
Correct.
Not, whereas what you've just suggested.
Well, what my Lord was encouraging would be a world in which, let's assume the profit's 1,000 and 100 is given on some kind of defeasible basis, and you say, well, the only fair thing to do is to value that at 30. But that doesn't lead to all 1,000 being taxed. It leads to 9,799 930 being taxed. So that serves to emphasise that when the statute talks about right, it means a right, not something that's contingent or defeasible or forfeitable. It has to be a right. And the single cleanest answer to the revenues PIP appeal is because of the possibility of forfeiture and or the exercise of a discretion that would reduce the amount possibly to zero, these individuals did not have such a right. Now, I have a longer answer, another hour's worth, but at heart, that is the single answer to this appeal. So my jumping off point for Ramsey was to say that if you look at the deed and think about the dynamic as between the parties, and you focus on the word right, I'd say there's only one permissible answer. Then the question is, well, is there something in the Ramsey principle, which we now understand to be a principle of statutory interpretation, purposive interpretation, taking a realistic view of the relevant facts? Does that make a difference here? And I'm going to say no to that. But what I was going to do is take it in two stages. One is briefly to look at the authorities, and that really means just looking at, again, a couple of passages in Rossendale. But then to turn to the question of the realistic view of the facts.
Yes.
Now, well, that may be a
All right,
convenient.
we'll stop there and start again at 10:30 tomorrow. Your short point here is that you're required to take a realistic view of the facts, not some alternative set of facts.
Correct. And there is an interesting question as to whose view of the facts, which I want to come back to. But I'm going to say it's the first-tier tribunal, with one slight variant here because the upper tribunal turned over the decision of the first tier.
Well, that's because the first tier said there wasn't any room for.
Yes. But I'm going to come back to that, but there is an important point of principle about whose view of the facts. I'll come back to that tomorrow.
Yeah. All right, 10:30 tomorrow.
All right.